Thanks for coming along, everyone. Really appreciate you being here. We'll get started. I'd like to start first by acknowledging we're meeting on beautiful Ngunnawal country, pay my respects to elders past and present, and show my appreciation for all their work marched toward reconciliation and closing the gap. Plenty of work to do here in the ACT, but we're very fortunate to live in such a beautiful place. Really appreciative of Dave for having us here to discuss a really important issue tonight. How we'll run the evening is I'll have a bit of a conversation with Dave to kick off, talking about the night of the incident here. That is the reason that we're hosting this forum at this venue. And then we'll chat with the panelists. I'll kind of moderate a discussion for half an hour or so, and then we'll throw it to the audience for your input and any questions that you might have. Before we do that, I think I'll introduce the panelists so you know who you're hearing from. First of all, we have Dr. Penelope Matthew, who's down the front. She's going to swap spots with Dave after we've had a conversation with him. Dr. Matthew is the ACT Human Rights Commissioner and President of the Commission with an extensive career spanning legal academia, research and public service. She has significant expertise in international and human rights law and offers both a practical and global perspective on how legal systems can safeguard expression while protecting the dignity and rights of individuals. We have Karen Tui, who's over here, who's the Discrimination, Health Services, Disability and Community Services Commissioner at the ACT Human Rights Commission. She brings over 20 years' experience in human rights, discrimination and complaints handling and has held senior positions across both federal and state commissions. And we have Dr. Danielle Ireland Piper from ANU.
Sounds better in an Irish accent.
Dr. Ireland Piper is an associate professor at the ANU National Security College. She brings experience in academia and private legal practice and across state and federal governments with a focus on constitutional, international and human rights law. She's published 4 books on national security and human rights. Danielle advises on complex legal frameworks and contributes to public debate on the limits of state power and individual rights, as she's doing tonight, and brings insight into how the Australian Constitution and Commonwealth law shape this debate. And then at the other end, we have Carlo Ritchie, who's a comedian and podcaster. He's known for his sharp observational humour, also on display tonight. He's promised me. He's performing across Australia's comedy scene. Carlo brings an on-the-ground perspective of how audiences respond to provocative material and where the boundaries of art, satire and humour are tested. He's also a brilliant podcaster, and I can personally recommend his podcast, Did Titanic Sink?
Question on everyone's lips.
Yeah.
Just about to ask.
We'll spend the second half of the evening focusing on that. And beside me is David Howe, who's the owner of the venue that we're in tonight, Dissent Cafe and Bar. As many will know, I'm assuming everyone knows, ACT policing came through here on the 18th of February in regard to posters or similar posters to the ones that are now up in the front window. And so I thought we could just kick off with a bit of an explanation from you of what that experience was like, how the night unfolded, and I might ask some questions. So,
Sure.
Yeah, Dave, take us away. What was it like that night?
Well, it's all a bit hazy now, but approximately 7 o'clock on Wednesday night, I think it was, a couple of ACT uniforms turned up at the bar. They parked their car out the front. They said they were here to investigate a reported incident, which involved the new hate speech laws, federal hate speech laws, and also I believe ACT has similar laws. They claimed, or they said at the time, that they were declaring the place to be a crime scene, and that no one was to touch the posters, that they had a complaint made to them which they were obliged to act upon. So they then stationed a couple of police officers to guard the posters so that they couldn't be interfered with, and informed me that a couple of detectives from the senior crimes or the serious crimes unit were travelling to remove the posters. There was a gig supposed to be happening that night, so the gig was cancelled. It did actually go ahead in someone's backyard, but the gig that was scheduled to happen here didn't happen.
And what was so we had an exchange on the night while the officers were here, and I was asking, what laws they were applying. What was the tone of the encounter, perhaps with the uniformed officers, and then later when the detectives arrived?
Yeah, so initially I thought it was just that they were saying, oh, we're here to have a look or something. My impression was they weren't entirely sure themselves what the basis of their actions were. They seemed to, they weren't definite about anything, and they used a number of contradictory, they spoke in a number of contradictory ways about what they were here for. I did offer to, I think I may have offered to remove the posters or just speed up the process so the gig could go ahead. But as I said, it's quite a while ago now, and I can't remember exactly what went down. But I do remember that they seemed unsure of their reason for being here and the actions they were being directed to take. I did manage to get from them the information that they had received a complaint, and it was relevant to the new hate laws, and it was specifically in relation to the display of the swastikas on the posters. As I said, my feeling was that they were a little bit embarrassed to be here. But that they was nonetheless here, and that they were going to make a point of being here and removing the posters. Yeah.
And you weren't given any notice because you had them up for a month or so before then?
They'd been up for about a month. Yeah.
And there's no notice given ahead of time.
Well, I mean, the whole thing is that, I mean, as it transpired, there was no breach of law. Any reasonable person, and I did point this out to the sergeant at the time, that they were clearly satire, and that they should be treated as such, and it would be obvious to anybody that they were satire. I don't understand why somebody just didn't take one look at them and go, "There's nothing to see here. Let's move on." I mean, 5 police officers, 3 uniforms, two detectives, for 2 hours for a non-incident. Seems like an incredible waste of police resources, particularly when there are other things more pressing. A friend of mine who I related the incident to, who works in the sphere of domestic violence, said she can't get police to respond to serious complaints that she has to deal with. And yet we have an anonymous complaint here, and 5 cops turn up and for 2 hours.
We probably should have mentioned, and I'm sure everyone's aware of what the posters are, but they're satirical, clearly anti-fascist posters depicting leaders like Donald Trump and Elon Musk in Nazi uniforms.
Yeah. I mean, they're on display, so
you can take
a look.
Way out.
You can download them from a father and son combination called Grow Up Art. It's on the internet. Just search for it. They've been all around the world. There's much larger versions than we have on display on billboards and on sides of buildings around the world.
Some people may have seen my reaction. I thought it was very strange, and I think that's how most Canberrans responded to the incident, but I'll throw to the panel to hear how they responded. I did want to check, though, what follow-up happened afterwards. So was it a week or so before they determined that actually the posters weren't illegal and came back to you? What was that?
Yeah, so like? Post the actual removal of the posters, I received a phone call from the ACT Minister for Policing the next day. No apology was given. I mean, it's just I guess a courtesy call, inquiring about my welfare. There was no more communication with the police up until the day the posters were returned to me. I do note that they put out a statement after I went on the radio claiming that I had refused to remove the posters, which is not the case. I suspected then, when they made that statement, that it wouldn't go to court, that there would be no test of the case, because otherwise then their body cam evidence will be put to court and they would be shown to be spreading, untruths. Anyway, so about a week later, they called me up and said, "You can come and collect your posters." So.
Okay. Yeah, where'd you collect them from?
City Police Station just down the road here. I mean, they can take them away, but they can't bring them back.
Well, I mean, if they brought 5 officers to bring them back, then that would have been a whole other story.
Exactly right. Much more efficient.
So I thought I'd quickly share, because I've been asking questions about this in the Assembly, and you touched on the use of resources.
Yeah. I should mention also before you go on, the Uniform Police cited both the local law, the ACT law, and mentioned that there was a federal law. The detectives were only concerned about the federal law. So, yeah.
Yeah, and this is in the response, which laws applied, why was contradictory advice provided by different officers. We learnt that the Commonwealth Criminal Code provides police with an express power to seize items that depict or contain prohibited symbols where those items are publicly displayed, and police reasonably suspect the display constitutes an offence. So you were indicating that you think, a reasonable person would not think it constituted offence. I did ask about resourcing, and the response from the police minister was that the number of officers deployed reflected standard operational considerations, including public safety, scene management, and the need to assess reported material, and is considered an appropriate use of ACT policing resources in response to a complaint, which I think is quite different from how most community members responded to it. What's the response that you've seen from Canberrans? People come in and chatted with you about it?
Sure.
I'm sure you received a lot of feedback. I think your social media following might have tripled, which will make it hard
certainly
to seek damages.
had an effect. So overwhelmingly, I guess the response has been extremely positive from the public. I've had phone calls from people as far away as WA. I've had visitors from the United States and UK actually come in and say expressly that they were here because of the posters. I've had email messages from people in the UK and in Netherlands. A bunch of emails from people in Sydney and Melbourne and all around the country, offering, expressing support. I think most people share my reaction initially, which was amazement, really, and astonishment that this is taking place when it's obvious what these posters are and what they represent. It's kind of ironic in a way that posters, the posters making such an obvious anti-fascist, anti-authoritarian statement, for the police to respond in the way that they did. I mean, it's kind of, it almost proves the point of the posters.
Okay, David, I might swap you out for Penelope, if that's okay. So
That's fine.
let's put our hands together for David. Thanks, Dave. Well, on the, I guess just briefly before we go to the panel discussion, I had the same sort of reaction myself. And the context for this conversation is obviously what happened, the Commonwealth laws that were introduced at the beginning of the year, but also the ACT government is currently reviewing our local anti-vilification laws. And so that sets a bit of context for why this conversation is important. Certainly the feedback that I was receiving from Canberrans was that they didn't feel the balance was right if that was the application of the laws. we have heard since that the Chief Police Officer has issued updated guidance on how the Commonwealth laws should be applied. I'm trying to get access to the guidance. I don't know if they'll provide it to me, but to be able to compare that with the guidance that was provided when the Commonwealth laws were passed. But I think it creates the space, hopefully, for us to have a really reasonable, thoughtful, respectful conversation about how we actually get this balance right. Because I think Canberrans deeply value freedom of expression, and also value just how inclusive of a community we have here, and see the need to protect people from vilification. So, it's an interesting time, an important time to have that conversation. Carla, I wanted to go to you over on the other side there, just to get your initial take on the incident. As Dave said, kind of like an authoritarian response to anti-authoritarian posters. You probably couldn't script it yourself.
Yeah, exactly.
What was your reaction when you saw the news about this?
Well, I mean, this is the kind of the comedy of what satire is, really, which is, satire blurs truth and fiction. And that's one of the problems why vague laws really struggle with satire, because they require some degree of critical thinking. The point there, anybody would look at these and think, oh, these aren't being serious. But when you have this sort of abstraction of black and white law saying this is an offensive symbol and therefore this must be an offence, it becomes this juggling act of people well, but the thing is bad, but it's not bad. And you can see the cogs failing to turn in the way that the law approached this process, right? You're having to explain why the chicken crossed the road for the police, Yeah, I mean, comedy always fails when you break it down, but that's that's kind of the joke of this too. Is the only way you can get out of this is to prove that it is a joke, which is in itself a difficult upward slog.
Catch 22. Perhaps to set the scene a little bit, Penelope, you could share with us what human rights law has to say about freedom of expression and protection from vilification.
And I should say that I think in this case there were exceptions, and that most people looking at the law would have thought the exceptions might have applied. That's one of the issues. And so when we get to the part where the real expert on vilification, the Discrimination Commissioner, talks about how it's applied, I think the issue will be how we train law enforcement personnel to understand and make decisions around this. But I think it is important to start off with what international human rights law and what our ACT Human Rights Act has to say about freedom of expression. Obviously, it is an absolutely central value, and it is protected in very important UN treaties to which Australia is party, like the International Covenant on Civil and Political Rights, which is what our Human Rights Act was initially based on. So freedom of expression is protected in that covenant. In our Article 19, it's also protected in Section 16 of our Human Rights Act. It is not an unlimited right, however. In fact, most rights can be limited. So if you think about our Human Rights Act, there's Section 28, which says that rights can be limited. They have to be the limitations have to be demonstrably justified in a free and democratic society, and there's a proportionality test set out. So government has to be limiting the rights in order to pursue an important purpose. The limitation has to be rationally connected to that purpose, and it has to be proportionate in the sense that government should be taking the least restrictive means. International human rights law actually goes a little bit further. So if you look at the International Covenant on Civil and Political Rights and the Convention on the Elimination of All Forms of Racial Discrimination, they actually require states to act and to have laws in place to protect against vilification, or what we might call racist hate speech. And that clearly comes from history. All of those human rights instruments are reacting to World War II and the Holocaust. And they recognised that the Nazi racist propaganda had a lot to do with the genocide that unfolded and the killing of 6 million Jews. So I think it's important to understand that context, that there is a need to balance one person's freedom of expression with other people's rights not to be vilified, because vilification really gets to the heart of your right to exist, your dignity, your equality, and even your freedom of expression if you're one of the targeted groups. Vilification's a very silencing thing to be doing to other people. So I hope that kind of sets the scene about why we're trying to strike this balance. Yeah.
Thanks, Penelope. I'll go to you, Karen, then on how we implement. Perhaps we could start with an explanation of your understanding of the new Commonwealth laws and of how they interact with, overlap with, or differ from the ACT's existing anti-vilification laws.
So, look, I won't purport to be an expert on the Commonwealth Criminal Code. And some of the issues are there are so many frameworks now with different tests and different thresholds and different language that it is confusing for people. So the Commonwealth Code talks about hate crime and hate speech. The Racial Discrimination Act, which also applies in the ACT, talks about offensive behaviour. The ACT Discrimination Act talks about vilification. The ACT Criminal Code talks about serious vilification. So we're already trying to reconcile those things. I mean, in some ways they're not dissimilar. So our criminal code, for example, with respect to display of Nazi symbols and those sorts of things, there are defences around academic, creative, scientific exemptions, and those also apply in the Racial Discrimination Act and in the Criminal Code. The issue in this sort of space is someone's looked at the poster, taken that little bit in isolation, instead of looking at the whole context. That's not news. I mean, I started working with the Racial Discrimination Act many years ago, and when the offensive behaviour provisions came into the Racial Discrimination Act, there was a lot of confusion about what that meant, because the test in that act is about offensive behaviour or something that insults a person on the grounds of their race. The test in our act is, does it incite hatred or incite violence against someone? So it's quite a complicated space. They do interact and we all have to work with them. I think when something's new, there's also that tendency perhaps to be very conservative in how you look at something. I think the important thing, as Penny said, is the purpose of these acts is to protect groups that get vilified. And the reason for that is because what we call low-level behaviours, like vilification or harassment, create an enabling environment for higher level behaviours. So they create that environment that can lead to violence. In the ACT, we protect disability, race, sex, a range of other attributes, not just race and religion. And so there's those complexities of work as well that are in operation. But the grounds in our Discrimination Act are reflected in our criminal code. So again, there's a broader application of the law here. Without getting into a Law 101 lecture, which I'm trying to
That's all right. I'll take you up on that after, if that's all right. Says the lawmaker on the panel. New to the job. It's all right. Danielle, as I mentioned, the government's reviewing our hate and vilification laws, and has flagged reforms likely on the horizon. They've committed to strengthening the laws in some way, which may or may not be in line with the new Commonwealth laws, which I know you provided submission into the consultation, raising some of your concerns. What do you see as the risks and also potential benefits of this kind of legislative reform?
Yeah, so first I'll just add one more bit of context, and that is that Australia is the only Western democracy, the only country that's a democracy that doesn't have a national charter or Bill of Rights. So we're actually highly dependent on legislation to guide us on this. And one of the downsides of that is that there are inconsistencies, as Karen points out. There's different words in all over the shop at different levels of government, and that uncertainty in and of itself can have a chilling effect on freedom of expression in and of itself. We do have in the Constitution what's called an implied freedom of political communication, and that's implicit in the idea that we get to choose our elected representatives. And what that can do is it can actually make legislation invalid, and it can actually have the effect of getting courts to strike down legislation if that legislation is burdening political communication, not freedom of expression, but political communication, in a way that doesn't have a legitimate public purpose, And if it does have a legitimate public purpose, if the means used exceeds what's necessary to achieve that purpose, so essentially proportionality by another name. And the reason I mention that is because one of the risks of this rapid hyper-legislative response we've seen to growing community tensions, and let's be honest, it's actually happening. We can see the statistics that since October 7, there's been a rapid rise in anti-Semitism, Islamophobia. Since The Voice, there's a rapid rise in acts of hate and offensive comments towards First Nations peoples. It's also on the rise in the LGBTIQ community. So this is not happening in a vacuum. There is actually a genuine social public issue of safety that people are trying to address. However, the problem with this hyper-legislative, let's just make all the laws problem is that there's legislation on the books in Australia at the moment that I think will probably be subject to constitutional challenge, particularly in Queensland, probably in New South Wales. And so I guess one of the risks with the ACT following suit is that you just create more uncertainty, because I'd be very surprised if we don't get a constitutional challenge against the Queensland laws. They're very draconian. And obviously the ACT might not look like that, but it does create more confusion. One of the risks in following the model exactly at the Commonwealth level is there was a tranche of incitement offences about a year and a half ago that included grounds of disability, sexual status, other types of identities that are protected, whereas the anti-Semitism and race hate bill is only focused on anti-Semitism and racial identity. It doesn't include other grounds, for example, around disability. And I know the disability community, for example, are concerned about that. So one of the risks in duplicating that is we may actually miss grounds. In my submission, I had concerns about a proposed hate offence, just to be clear, because this is something I don't think the community is clear on. That hate offence didn't survive. They actually took that out. And one point I think that needs to be made about this lawmaking, and I hope the ACT government does a better job of this, is the way that we communicate about laws matters as much as what's in them. Because I'm getting all these phone calls like, can I do this? Can I do this? People are nervous about getting arrested. So even though that offence didn't make it into the bill, the way the law is being communicated makes people think that it is. People are confused. And that in itself is having a chilling effect on the way we're communicating. And it's actually causing more tension than what's fixing it in some ways. One of the benefits of the ACT getting on board with this is that we are a federation, and there's some really good things about being a federation. Dividing power, absolute power corrupts absolutely. It's great we have different tiers of government, but one benefit, to answer the risk and benefit aspect of the question, is that then maybe we would have greater consistency. And consistency in itself is better for the community, because then at least people know what's what. So I suppose that would be one potential benefit.
Yeah.
Yeah.
Well, you make a good point about how things are communicated, so I think with the incident here, there'd be far more people who knew the incident occurred
Yes.
than the number who knew the posters were returned.
Yes.
And so that's likely to have an impact on behaviour anyway.
And in this case, I'm really glad that Dissent Bar got free publicity. This is a great community venue. I was here seeing a band on Sunday night, really glad for that. But you make a really interesting point. Sometimes by elevating an issue, by legislating an issue and hyper-legislating it, you actually elevate its status.
Right.
Ironically, yeah.
Perhaps one for everyone on that, and I don't know if it's going to be one for the Human Rights Commissioner here, but is there actually a need to strengthen our anti-vilification laws in the ACT? Is that something that's clear to you? Maybe not, I'm not sure if you have provided an opinion or if anyone else has a view.
Well, we have written a submission, so Karen might want to talk to that. It's a very good submission. I've signed off on it too.
I was heavily involved.
Yes.
Yeah,
On the back page, the appendix. I think our view is that we actually have a really strong framework already. There are some minor tweaks that we are suggesting. So, for example, don't cover age vilification. I work in the elder abuse space, and that's a bit of an issue. We've recently brought in vilification on the grounds of sex into the ACT legislation. So we've already strengthened it before this process commenced. I think, again, our view is we want to see what community says. Are there particular issues, or are there particular barriers people see to, for example, bringing a complaint to the Commission, reporting to police, in those sorts of spaces, rather than necessarily the legislative response? I think one of the things that we worry about and we traverse in our submission is that we can't just rely on the laws. It's actually, as you've said, it's what the messaging is. We want to be a safe, inclusive, diverse community. And so it's not just the responsibility of those sitting in the Assembly, good job that they're doing. It actually is the responsibility of all of us. And one of the examples that we use in the submission is a couple of years ago, there was a pamphlet distribution in one of our suburbs, and it was a Australia for the White Man pamphlet, which was pretty offensive to a lot of people. And a number of people contacted me about that and contacted the Commission. And the view, you know, they were scared. They actually thought they'd been followed home or it had been delivered to them individually. It then became apparent it had been delivered to a whole range of people in that particular community, unfortunately. But the thing that happened a couple of days later was people in that community came up with their own pamphlet and put it in all those letterboxes saying, we love you, we care about you, we're a diverse community, that's not who we are, we welcome you to our community here in Canberra. And so I think we need to think about not just the legislation, but those other responses, and that's what we're keen to hear about coming out of, you know, the hate crime review, because I do think there is a tendency, as we've seen at the Commonwealth, to sort of think legislation is the answer to everything. I think Penny would happily say she's going to spend she's going to spend the next couple of days looking at other bits of legislation that have arisen out of some recent events. Bondi, one of them, Queensland, another one. And there is a lot of concern, I think, about how far are those laws intruding into people's privacy, you know, how many honeypots of personal information will be setting up around the country. Are some of these laws really the appropriate response to some of the issues that we're seeing, versus the focus on social cohesion and actually acknowledging that we are a diverse, safe community? How do we let the community express that, not just how do we try and deal with it through legislation?
For you, Carlo, obviously comedy, part of what comedy does is push boundaries and explore areas that people like politicians might not be as permitted to explore. Have you noticed a shift in audiences, like our audiences becoming perhaps less on board with offensive material, more sensitive to its impact? And along those lines, do you find yourself self-censoring in your comedy, wondering how this will land?
Yeah, I mean, look, the best thing to think about, really, like, comedy can cause offence without it being vilification, you know, or without it being something that incites hatred. You know, like, I think this satire is a great example of where, you know, the act of causing offence is kind of part of the humour and the way that it works. And one of the metrics that we use very often in comedy is like, is this a joke that's punching down or is it punching up? You know, like, you have to look at who the subject of the joke is to be able to interpret whether or not it's offensive. You know, like in this case, like these posters, who's the butt of the joke? Like, it's clearly these global leaders that are the butt of the joke, or if you want to look more broadly at fascism in general. And, you know, so when you get into that kind of ambiguity, it's kind of funny to me. It's like, well, these areas of exception in these laws, does that mean that I have to go and teach the police the essentials of what a joke is? You know, like like I was going and doing comedy workshops on whether it's punching up or whether it's punching down, because that's really, I think, the best metric to judge it by. Like, as a society, I think what we will tolerate shifts almost universally. Like, it shifts with society. Like, jokes that people were making 30 years ago, like hugely successful comedy specials. Like, even you can look at like specials from the 90s will make jokes that are hugely offensive to a modern audience, because you understand they are punching down against marginalised groups that don't necessarily have a voice. and that's, I think, the best way to judge any comedy is like, who is the butt of this joke? And is it a group that can't really defend themselves in a public sphere because they're marginalised, they've been put down by various other apparatus? Or is it somebody who has infinite ability to defend themselves and probably is deserving to have the joke made about them? And if you're the person that it's causing offence to, and it's not punching down, it's probably time to rethink some of your ideas, maybe.
Yeah. The growth industry and comedy consulting for you.
Yeah, exactly. Yeah.
Now, literally, will all the failed comics end up doing comedy consulting?
Yeah.
Please. Yeah.
You heard it here.
Copyright. For Penny and Karen, I don't think we've spoken on the existing avenues in the ACT for someone who feels that, that they have been vilified. I'm not sure who's best to take it, but what are the avenues? Because we've seen what it can look like when police get involved, and Carla's spoken to this. But what are our other options?
Sure. Do you want me to take that one? Yep.
She's the one who does it. So.
Call Karen. It's the other option.
I've got a T-shirt that says. So at the Human Rights Commission in the ACT, we have a complaint mechanism available under our Discrimination Act, which enables people to bring a vilification claim if they feel they've been vilified. That's anything that happens in the ACT. As we've indicated, it covers a whole range of things. So disability, sexuality, race, religion, now sex. And so it's a pretty broad remit that we have. Race is in there, obviously. We get a relatively small number of complaints, and in the conversations I have, particularly with some of our community members from the multicultural community or the disability community or the LGBTIQ community, there's a barrier in terms of people can be afraid of making a complaint. I'm going to make a complaint against the person who just vilified me. Yeah, not always sensible. That can be a barrier. One of the barriers, as always, is just I want to get on with my life. I don't want to keep going back and trying to deal with this particular issue. On the other hand, it can be a really useful process in some circumstances. So, for example, we deal with a number of matters in sport where there's been vilification between teams for various reasons. Those matters will often resolve through our conciliation process. We deal with some fairly nasty neighbourhood matters. We have some on foot at the moment, unfortunately, where it might be a joint response between us and the police, going to talk to people about, actually, you can't make those comments, you can't threaten people based on their colour or their racial background. Obviously, bringing a complaint is usually not the first thing that people do, but we do try and make the process as accessible as possible, or we try and make sure that people know they can give us a call and we can talk them through their options. So they can come to us, they can go to the police. In some circumstances, they could also go to the Federal Human Rights Commission. So there's a range of options. I think the other thing that some people don't know is because we have quite strong powers in what we call the own motion investigation space, if somebody's concerned about bringing a complaint, so for example, we've dealt with a number to do with various online providers or various social media providers, they'll bring the issue to us, or it might even be a friend or an ally that brings the issue to us. And then I become the complainant and it's me going to deal with that agency about getting material taken down or what the sort of outcome is. So there's a range of pathways for people, which is why we sort of try and encourage people to make contact with us rather than self-select out. But I think it's just the harsh reality that often people feel that it might be too complicated, it might be too confronting, it might be too technical. We put a huge effort into our complaint mechanism here to make it as accessible for people as possible. Certainly we've seen some really good outcomes when I think people are surprised that a respondent in a vilification matter will come to the table. In some of those matters, for example, like with sport, it might not be the individual. What it will be is the team representation. And so we've been able to get some really good outcomes in the education space and that sort of thing. So there are options for people, but as I said, it's an ongoing conversation with community members about, is that the process they want to follow? Do they want me to write in a sort of educative role? I think in our submission we mentioned one matter where someone contacted us because someone in their complex had all these white supremacist stickers on their car. They didn't want to confront them. So we went and met with the neighbour. We talked to them about their car. We flagged for them that actually they were in breach of the law, not just my law, but some other laws as well, and negotiated an outcome with them to remove the material and then to provide us evidence a few months later that the material had not been reinstated, and work with the neighbour to sort of work on that. So I think there's some creative things we can do. It's not just about, I've been vilified, I have to bring a complaint and talk to the person who's done that to me. It's a good submission.
Yeah.
It's a great submission. It's a
We
great
worked really hard on it, actually.
I've been reading it. Yeah.
I'm looking forward to getting out in the world.
Yeah, Carla, can you talk us through your submission to the review? No, I'll go to Danielle. We've touched on it a bit, the broader conversation around social cohesion. I wanted to ask about, and we've touched on this as well, when you legislate, is that improving social cohesion? Could it, does it, or is there a risk of, sometimes actually inciting further division and mistrust of governments and other institutions?
Yeah, look, I'm fighting a losing battle on this one, I know, but I'm actually starting to really dislike the term social cohesion. What national security folk mean is please don't get radicalised and kill each other. That's what they mean. But the way that the term is translated into the broader community has become a proxy for all sorts of other things. And I'm very aware that there are communities that hear homogeneity, like the idea of cohesion, meaning you all have to be the same. Now, autocratic dictatorial societies are very cohesive. And I think what we're actually aspiring to socially, separate from national security concerns about us killing each other, separate from that, what we actually want is peaceful pluralism. Yes. The ability to agree, to disagree agreeably. We're losing a little bit as a culture, and we need to be able to do that. Now, to the second part of your question is, are the laws helpful in trying to achieve peaceful pluralism? Like I said before, it's not legislating about nothing. There is actually a genuine concern here. When I mentioned before that incidences of Islamophobia and anti-Semitism have gone up, I'm talking about like over 600, 700%. We're not talking a little bit. There is actually a genuine risk. There are foreign actors who are genuinely trying to cause disunity in the community. It's a deliberate strategy. They don't actually care who picks on who. They're a bit agnostic about that. But what they're trying to do is sow division, because division is disruptive. It can distract the national security apparatus. It can distract from other types of more important issues. It's an actual thing. So broadly, I'm supportive of the Commonwealth laws in the last couple of years. However, I'm quite concerned about, as I've mentioned, the Queensland legislation and the New South Wales legislation, because what I think has happened is it's actually unintentionally pitted law enforcement and the community against each other in the very circumstances where we need to be trusting each other and working together more. I'm sure you all know people who turn up to protests and what have you, and I'm starting to listen to people who do that, and they're starting to, you can sort of see this shift where they're not just protesting the issue, they're protesting the protest laws. And social cohesion is starting to sound like this sort of, get out of jail free card, it's for social gain. People, it's actually undermining, I think, trust in a very genuine project, a very important genuine project is how we exist together as a peaceful, pluralistic society at a time where the world is pretty tense. We're in a polycrisis. There is really serious geopolitical conflict. There are foreign actors who would seek to do us harm. We're 2 seconds to midnight on climate change. We actually need to be working together and cooperating and being able to test a marketplace of ideas. And I am concerned that the way the legislation has been rolled out, particularly at the state level, is doing damage to that project.
And I think just to jump in on that too, it's a question of how the law is applied. And I think the Dissent Bar incident is a classic illustration of how things can go wrong. And when the Commission was asked for some public comment, we made the point that actually misapplication of the law can sow the seeds of social disharmony, the opposite of cohesion, by engendering distrust that, you can do something that you think should be legitimate and you're going to find you're being clamped down on. How's that going to promote a harmonious society?
It's also not fair on police either. I'm sure most police officers don't go to work going, great, I'm going to go get some artwork. Yeah.
Yeah, and I have a bit of a frustration that we haven't heard any kind of commentary saying, not like, okay, Dave got his posters back, had to go pick them up, but he got them back. But to say this was a mistake, this is not how we are going to apply the laws moving forward. Because I think there is a bit of a residual fear that if you have some racy posters up, someone might come in, shut the venue, grab the posters, check if they're legal, decide they are, bring them back, and that's just how things are going to operate.
And then you have a great public event.
Yeah. And then I'll run another forum at another venue. So I'm looking forward to that happening. But I kind of think we need that reassurance, that this was a mistake. But it's just it can be a challenge with certain institutions not wanting to say those sorts of things. Okay, so if we agree that certainly at times at least police might not be best placed to make these kinds of judgments, and that puts them in an unfair position as well. Final question, and I'm keen to go to the floor after this one. For the panel is, are there more creative ways, you've touched on them already a bit, Karen, about how we bring community into a bit more of a deliberative process when it comes to determining, what is and isn't okay and drawing the lines? Is this something that's an option for us? Can we get more creative in the ACT to lean into that kind of, I think what we actually all have, which is a fairly good common sense understanding and willingness to listen to other people around what they, find to be crossing the line. Do we have any views on how we might be able to do that?
Oh, is it me?
Don't look at me.
Is that a question for everyone?
It is
For everyone.
Is that for everyone?
Yeah, for everyone. Yeah.
I do think that there is a place for education, civics, literacy initiatives. I think events like this, I think we need to start talking to each other more. I just want to also make the point that national security is the means, not the end. So national security is designed to protect our liberal democratic values as much as it is to protect us from militaristic threats. And so we need to be careful not to use that as a proxy for sort of shutting things down, but having genuine conversations. And this will probably sound a bit self-serving, but my place of work, the National Security College at ANU, we just did a nationwide consultation with the community. We went out to regional and remote communities. We did 3 tranches of surveys. I was in Queensland, in rural Queensland, talking to people and asked people what they think. And what they're scared of, and what they think national security is. And actually, out of 4 priorities we put to them, stuff around economics, human rights, things like that, people actually rated safe and peaceful communities the highest by far. And so that says something about what the community is thinking. And I think there is more of a place for people like yourself, but also for our Prime Minister and other leaders to have more of a conversation with the community about what's happening. What we did see in that survey is that people actually, about 75% of people, 2/3, want more information. And I've got a colleague, Ron Levy, who does a lot of work on consultative democracy. And there's a lot of studies to suggest that you can trust the community with more information and with more difficult conversations than what we tend to. We tend to think, we can't trust the public with this information, or it's too nuanced. Actually, we have to have those difficult conversations. And I think in some ways that's, I support laws, I'm a lawyer, but we can't legislate ourselves out of everything. I think we need to have adult conversations about these issues.
Definitely a role for more education, and I think human rights commissions have a role there. I would say I don't think we're very well funded to fulfil that function, to make a plug of our own, because we're very happy to come out to community fora and talk with people. We'd love to get into schools more. In my side of the house, the human rights side, I have a whole 2.5 FTE and me. That's the team. Yeah.
Gosh.
Fortunately, we've got KT's team of complaint handlers as well, and other areas. But we are we are a bit stretched, I think. The other thing that and I wonder what Danielle in particular thinks about this. I mean, thinking about some of the outrageous statements about immigration recently, immigrants being scapegoated for all of the social ills in our society. What drives some Australians to make that kind of easy leap from, gee, it's hard to buy your own house, for example? It must be the fact that we've got an immigration program, never mind that it's been going for centuries now. Is part of this that there's growing insecurity in the community, and we need to do a better job of providing for people's socio-economic rights, because more insecurity tends to breed more of this intolerance and behaviour like that. And Katie might have some reflections from practical experiences handling complaints as to what might have been driving people to say the things they do on occasion. So I think that's part of the puzzle here that we're not tackling as well.
Well, the public narratives around other, I mean, that historically clearly has been part of the problem, and one of the reasons why in the ACT we have some diversity in our protections around victimisation and the discrimination laws is because we recognise that we have to signal to community that these groups do get vilified or harassed or discriminated against, and we don't want that in this community. I think one of the benefits in the ACT is we're all 15 minutes away from each other, and so there is a closer relationship, I think, between government and community here than certainly in some of the other settings that I've worked, for that reason that they're at the shops together or at the Multicultural Festival or at an iftar dinner or something like that. But I think there is a need to ensure that we're not consulting the same groups all the time. And I think we see that in some community groups that there's fatigue around that, when actually the community is really diverse. I mean, the range of people that I work with in my team who handles complaints across a whole range of areas, it is extraordinarily diverse compared to what I was told it was going to be like when I came to Canberra a few years ago. And I think sometimes that's missing, and that's up to people like me and Penny to keep reinforcing that, but also up to our representatives to ensure that the voices within that diverse community are represented, so that we're not doing consultations just through Legislative Assembly inquiries that require written submissions and those sorts of things. I think the other things that we try and do to make sure community have some knowledge of us and have some knowledge of the options available to them and have some knowledge of their responsibilities as well as their rights is, we do a whole bunch of advertising. I certainly do a whole bunch of going out to community groups and things like that. I think sometimes people are surprised when they ring us and we say, yes, 150 people at the university of their third age, I'm on. And so for you guys here tonight, you're also, family members, mums, brothers, sisters, cousins. If you see things happening in community that you think shouldn't be happening or are unfair or discriminatory or vilifying, by all means, you can reach out to us and have a think about options or refer people to us. Like I said, we're 15 minutes up the road. So one of the things the Commission really tries to work on is how do we make sure that we're accessible to the community so that we can play our part in making sure that these sorts of behaviours and actions don't continue.
I promised to go to the floor, but can I throw to you, Carlo? It sounds like you're about to say something anyway, but we're 15 minutes from each other everywhere in Canberra, but I know you're paying close attention to what's happening online and how, hatred's being stoked there and division might be stoked there. I wondered if you can just comment that. I know I said...
Yeah, totally. Look, you know me, I'm the owner of a slowly growing comedy consultancy here in the ACT. But it is interesting, like you mentioned earlier, the idea of self-censorship. And I think ultimately self-censorship is kind of the ideal of where you should exist in terms of you are thinking critically about the things that you're saying and doing and deciding not to do those things because they would be harmful to another person. That's really an ideal situation to be in. And often the people that you find that rail against self-censorship are the people who have those problematic views that should be curbed in some way. And I think one of the problems that's really facing us more broadly as a society now is that there is now a platform where at one point, if you had a horrific view that your family were all like, oh, that's crazy old Uncle Rick, let's not talk to him at Christmas, is that you can now very quickly find a massive following of people that will support you, some of whom are real, many whom may also be fake. But you can create very quickly a vacuum chamber that supports those views. And as a consequence, a lot of people aren't questioning the views that they have and are in fact thinking that their views are the views of a mass. And that, I think, is probably the biggest difficulty to us as a society, is how do we take on a multi-billion-dollar project which is designed to amplify everyone's individual opinion as some kind of messiah-like text. I've said to you before, like, there's this growing manosphere of like really jack dudes who for some reason think that gives them then a reason to decide on immigration policy and racial vilification laws, as if like the muscle mass is somehow like gives them more thought power.
It's in the protein shake.
Yeah, exactly. And I think that's a worrying thing, that all of these wonderful education programs that have been spoken about on the panel, and like the critical thinking that is going into these programs, are being outwashed by a device that is deliberately whiting them out, so to speak. And that's the kind of way I like to just, bring the humour into it.
Yeah, thanks for that. Uplifting.
But on that, I mean, there is a place in schools to develop those critical faculties. I mean, we've now got a social media ban that we could probably talk about that, and there are lots of issues involved in that. But teaching you as you grow up to exercise those critical faculties and not just believe everything you see online is going to be important. Yeah.
I know we're going to go to the floor, but just to respond briefly, I think you're absolutely right when you make the point that if people are vulnerable and don't have housing and are struggling in a cost of living crisis, then, it's the oldest trick in the playbook, right? You blame another. And so there is something to be said for looking out for people's social welfare, socioeconomic welfare, as an anecdote to rifts in our social fabric. I think that's absolutely true. I think it's also really problematic, the way in which you're talking about the sort of vocal minority type thing. But just to add one heartening story is recently, as part of these community consultations, we engaged a lot with local government. And there are local governments in very remote rural communities that, some of us who live in cities might think are a bit sort of, redneck out there, that are actually thriving multicultural communities with over 100 nationalities. And local council are doing so much good work around sort of bringing communities together. And so maybe the answer lies on a different platform, really, rather than trying to fight it here. Yeah.
Great point. Okay, we promise going to the floor, but actually we're going to wrap up. No, I'm kidding. So keen for any input, questions for anyone up here. And I think we have, who's going to be racing around with the microphone? Hannah, you're going to be selecting as well, so
Power.
you've got the power.
My name's Michael White. I'm with an arts advocacy group in Canberra called the Children's Group, and a lot of arts colleagues have been extremely concerned about what's happened here. It would appear that the legislation was a great overreach. One of the things I couldn't get my head around, with the brand new law, I was wondering what was going through the mind of the senior police officers and then the junior police officers who came here with a brand new law. I would have thought from one complaint, they may have come here, taken a photo and gone back and said, what's this all about? Yeah. The fact that they didn't do that, I just wonder, maybe that's a question for Thomas, what was the thinking of the police that they had to act on one complaint which ended up closing this venue down? Yeah. There's a film on at Dendy at the moment dealing with the Nuremberg issue, a whole bunch of people walking around in uniforms with Nazi swastikas on it. If I rang the police and said, I find that insulting, would they go and close that down? So I'm just wondering, wouldn't a reasonable senior police officer think about, this is a brand new legislation, what should we do about this? Let's come down here. this seems a bit weird, let's go and get some advice, would they seek the advice of the DPP? And that's where I start to get a little bit worried. Not only the Minister for Police should have some response, but maybe the Attorney-General, in their thinking, were they consulted at all? So that's a rather long way. The other thing, I know a whole bunch of arts workers are going to apply to Arts ACT to run workshops with the police, comedy workshops, satire workshops, and maybe also with
You're behind the curve, Carlo. Sorry, mate.
So,
Always one step ahead.
no, you're way behind.
It's kind of a comment, but I think I share your view.
And some of the confusion was said in the introduction when you were speaking with Dave, that there was some unclarity about which law was it anyway, federal or territory. It seemed like there was very little thought given to the exceptions. That's my
That are in the
gut
list,
reaction. But
It was also in the context of coming off Bondi.
Yeah.
And so I think potentially, and we
I
don't
suspect
know
that's
the
the
nature
case.
of the complaint that was made, and we certainly wouldn't purport to understand how police think. As human rights practitioners, that's not our job. But I do think in that context that legitimately having a look at what's going on is one thing versus what the next steps were. Certainly, historically, we've had complaints. I've had complaints about the Israeli posters out the front here. I'll just confess that. We didn't contact the bar. We dealt with that. So I think that in that context, there was a need to be seen to be to be responding rather than just letting it slide. Sorry.
Oh, I mean, I agree. I don't think we can get in the operational space of the police. Like, obviously, I don't agree with what happened, but as you say, it was post-Bondi. Between 2014 and about 2024, there were 22 mass casualty attacks that were disrupted by law enforcement, and sometimes you don't hear about that. The success is in the silence, the success in that didn't have it. So I'd hate to comment operationally because I don't know what the complaint was, but obviously it manifested in a poor way, and the legislation does contain those exceptions anyway, so it is odd.
I think so. For me, it goes back to what I was mentioning before. We'd heard afterwards from the chief police officer that guidance was issued when the laws were passed, and I think the fact that the laws moved so quickly would have made that difficult to issue good guidance. But that new guidance was issued after this incident. So I think that in there's an implicit acknowledgement that the original guidance wasn't good guidance, but we still don't have any kind of assurance as to what the new guidance is. So I've put in a question through the Assembly to hopefully get that released. But just maybe have a bit of concern that they will say, look, it's an operational, we can't release operational details like that because we got to outsmart the offender. But if we get it released, I'll make sure that we send it around to people who are RSVP to today's event, and anyone else can reach out. It should be in the next few days that we get a response.
Hi, my name's Gregor. Just a couple of quick points. I've been in compliance management around the world and in Australia in major programs for 40 odd years. And I remind people to go back and read the Braithwaite Triangle, which is the fundamentals of basic compliance. It's worth reading again. My point is that the political band-aid that is these laws sit over the top of a chronic disease. Now, the band-aid is necessary for the worst of the worst offenders, and you need those laws. So I'm not complaining about the law per se. But I think our problem is that across the community, you saw things like robo-debt, where hundreds of thousands of Australians were in the vulnerable area, were disadvantaged by a government process, which essentially made them feel uncomfortable about government. That's just one simple example. You see policing with Indigenous people is often a common complaint where they perhaps overdo it a bit. So my, big issue is that unless we deal with the root causes, which is the bottom end of the Braithwaite Triangle, we need to start to work on those people that are most likely to join a hate group or most likely to do something, unless we get back to the, and you made the point about the community, some communities up in the bush, they work really closely together. And I think our politics at the Commonwealth level in particular tends to be frontline newspaper rather than seeing this underlying problems being fixed. No one has been held accountable for the robo-debt. And I think a lot of people are particularly concerned that a major crime which caused thousands of people to take their own lives goes there's no policing or anything on that.
It's a comment about trust in public institutions, trust in government, and how failing vulnerable people fractures that trust. And how do we get to the root of actually supporting people in our community who need our support to address those issues? I don't know if Danielle, from your perspective, you've got something to add on this.
No, I mean, you're right. Sometimes we address symptoms rather than causes, and sometimes you have to do a little bit of both. But of course, focusing on causes and things like de-radicalisation programs are important, although sometimes certain communities can feel targeted by those, and that can be an issue in and of itself. But yeah, I mean, the robo-debt actually is a great example. It's a little bit off topic, but it's a great example of why public servants still have a duty to speak truth to power. I'll just say that.
G'day guys, Matthew Lillywhite. I'm an ANU student studying international relations, but I'm also a public servant specialising in legislation. 2 quick points. The first one was the federal legislation doesn't talk about satire. It talks about academia and science and religious reasons, nothing about satire, where I know that some other jurisdictions do explicitly have an exemption in relation to satire. So I'd be interested in your comment, and particularly the federalism aspect of it. Is that a gap in our legislation that federally satire isn't necessarily an exemption, but at the state level or territory level it may be? The second point is the Australia not having a constitutional human rights framework means that we've had to have a legislative hodgepodge, and including part of that's mostly anti-discrimination is how we've mostly dealt with human rights in Australia. Whereas a lot of people, particularly my age, are fairly influenced by the United States system, where there is that more affirmative, I have a right to, I have the right of, etc. I'd be interested in your comment on whether or not we need to be rethinking our approach to be a bit more like the United States, in that people, instead of self-censoring, they're self-advocating for themselves. You can't say that because my rights are, as opposed to I shouldn't say that because your rights are. And I'd be interested in your comments on whether that framework of a more American way of thinking is a better or worse approach for Australia.
I have a strong opinion on that, but I'm sure Bill do. I took the last one, so you can go first if you like, but I do have opinions on that.
First of all, on the exceptions, I mean, I think Karen made the point earlier that it is a problem when you've got different language used, even though I think
Artistic is in there.
yeah,
Artistic, yeah.
there would have been other language, other exceptions that would have picked it up, and anti-fascism and so on. So it's maybe not such a big concern, but it is concerning that we're using different tests and different language. You know, consistency would be a good thing. On the First Amendment, I should put my hand up. I was actually born in the United States. I've studied in the States. I was married to an American at one point. I just think the approach to freedom of expression in the States is too broad. And as we've seen with the current president, it doesn't necessarily mean that you've got a whole lot of people standing up and speaking truth to power. And, you know, I mean, I like that argument about the best answer to bad speech is more speech. And I think there should be more speaking out and more calling people on anti-immigrant sentiment and so on. There's been a bit of that in Australia. But I do think the First Amendment is very, very broad, and it's actually out of sync with international human rights law. Now, you might say, well, philosophically, I've got a different approach and I'm more in line of the counter bad speech with more speech, and I like the American approach better, but it's not what's in those international agreements. Now, not everyone has actually signed up to all of those agreements. In fact, Australia has some reservations in relation to those provisions I talked about earlier, where there's a requirement to legislate. So for Article 20 of the Civil and Political Covenant, Australia basically reserved the right not to legislate at all. And on the Convention on the Elimination of All Forms of Discrimination, we kind of said we'll get around to it, at the earliest opportunity. I think the language might be in 50 years later. We've done nothing about it.
Haven't had a chance.
But yes, the First Amendment's an interesting one, and there'll be a lot of strong views, I think, about that one way or the other.
Yeah, but no, I don't think we should be like the American system for those reasons. I think a better model of constitutional rights entrenchment can be seen in the Canadian Charter of Rights. So as you may know, what they do is they have a Charter of Rights, but they have a derogation clause, which says that a right can be limited where the limitations are consistent with a free and just society. And that sort of marries with that idea that most rights aren't actually absolute. They have to sit alongside and in tension with other rights. So, the freedom of expression sometimes has to give way to someone's right to be safe. And absolutely take the point that in an ideal world, oxygen is the best hygiene for a really bad idea. But the reality is we're living, particularly with sort of, the social media era where it's just everything's on steroids, and the idea that anyone can have an absolute right and live together in a society is actually a misnomer. So I'm personally a big fan of the Canadian model and think that would be here. But even at a very bare minimum, we're not going to get a National Bill of Rights anytime soon. We don't particularly do referendums very often in Australia, unfortunately, because they can have a civics literacy effect. I think if we talk about a constitution more, we understand it more. But even just a basic right to equality in our constitution, there'd be a whole bunch of rights that would flow and protections that would flow from that, instead of, as you pointed out, having to constantly rely on anti-discrimination law.
But the other thing, I guess, to stress is, so the ACT was the first jurisdiction to have Human Rights Act as opposed to anti-discrimination law, and I won't say that our Discrimination Act isn't important. Karen would be very cross about that. It is important. But, we were the first jurisdiction to adopt a Human Rights Act, and we drew on places like Canada and New Zealand and so on, rather than going for the constitutionally entrenched model that the US has, which has lots of difficulties about it. If you didn't start off with one early on in the life of the Constitution, you have to have a referendum. We know where that goes in Australia. It's very hard to have a referendum. But the other thing, do you trust courts always to do the right thing? They're human as well. They can make mistakes. So the model we've got in the ACT, drawing on the Canadian model, is a dialogue model where all three arms of government have something to say about human rights. And instead of striking down legislation, the most that the Supreme Court can do in the ACT is issue a declaration of incompatibility. And then that then goes back to the Legislative Assembly to think about what should it do. The court has said in its opinion this legislation is incompatible with human rights. What are we going to do about it? Now, it might be that they do nothing. We actually have a long-standing declaration of incompatibility about a presumption against bail in our Bail Act that hasn't been acted on. But in theory, I think that's a nice fit with Australia because we are a pretty democratic country and we've relied on democracy for a long time to protect our rights. And sometimes in the States you can see the court gets it wrong, and there's a lot to do there with how judges are appointed, and it's very, very political, and things can go very, very badly wrong. And rights that you thought you had, you think about Roe versus Wade, for example, are taken away by the court, 30 years later. So,
which is why they should be entrenched in a constitution.
Well, yes, but if the court then gets it wrong, you've got to live with it for a very long time. So it's complex, yeah.
Look, that's. Sorry, I'm butting in. Sorry, I'm butting in right now. The whole thing with Roe v. Wade. Look, I'm perfectly happy with freedom of choice. The whole thing about Roe v. Wade is it's been completely misrepresented. what Donald Trump finally supported was the Constitution said the federal government doesn't have any right to make any rules whatsoever. He sent them back to the states. So he did not actually fit.
It's a federal versus state issue. Yeah.
It is federal and state, but
federal can't legislate on it. Send it back to the states, and all they did was follow the Constitution.
But the court is also involved in that decision making. It's not actually just, I mean, President Trump does like to issue a good executive order and try and think he can do things that are incompatible with the US Constitution at times. But the court is involved, and if you put all of the power, instead of having this dialogue model, in the court's hands, then you have to live with those decisions. So,
in this case, what the court did was support the Constitution as it stood. It was a state issue, it wasn't a federal issue. Now, look, I'm perfectly happy for freedom of choice. I'm not against that. But I'm just objecting to be represented.
Well, there are different takes on that. There are many US constitutional lawyers who take a line.
Yeah. We're still talking about the ACT's anti-vilification laws, or?
If I could just go back to the point that you made before of whether it should be, rather than people having to self-censor, being able to self-advocate. Like the point that I would make about that is I think really the ideal should be that people make a choice in their mind to not do racial vilification. There should be a point in which they go, this is a terrible thing that I'm considering doing and I won't do that, rather than relying on the victim to be the person that then says, you are racially vilifying me, or you are objectively doing something terrible to me. And the problem that I think you often find when you enable freedom of speech in a similar way to the United States is that then becomes an enabling tool for problematic views rather than a defence against problematic views far more often than not, because people then feel a certain entitlement to be able to say horrific things because it's some expression of their views. It's that freedom of thought, so to speak. Regardless of the outcome that it has on individuals. And that's what I mean more about that self-censorship, is people taking that step in them to mentally go, what I would say or is about to say is a probably horrific thing, so it shouldn't be said.
Do we have one more question? We might finish on this one.
Yeah, hi folks. Thank you for your time tonight. I recently moved to Canberra 8 weeks ago from regional Queensland.
Welcome.
So it was quite a surprise to see what happened in this venue happen here and not in Queensland. But since then, obviously, Christopher government has passed their, I can't remember the actual name of it, but it's to do with keeping the guns out of terrorists and stuff like that. And there's an artist, Nordacious, who's an independent artist who has used phrases like "from the river to the sea," globalize the Antifada in his artwork. He's currently has some of his artwork at the Museum of Australian Democracy on show at the moment. He's had to take down his artwork from his website because he is based in Brisbane. I'm just wondering if Dave was to put his artwork in the window, would that then warrant a visit from the Queensland Police Service?
Are you asking, there's two questions there. Are you asking, could the Queensland Police Service come to ACT? Because if that's your question, then no, because of jurisdiction, but I don't think that's what you're asking. No. You're saying...
Basically, because of federation and each state has its own, they can decide. So you've got New South Wales have gone balls in, Queensland's gone balls in, other jurisdictions have held back a bit. Where are we? So like, if I can't now buy that poster of Nordacious because he's taken it down in Brisbane, but it's still legal to have it here, but it's not legal to buy it. Well, he doesn't know yet, and because he's an independent artist, as Kathy Wilcox and came out today and said, the fact that they're going after an independent artist with no one behind him to support him to actually, because it's costly to go into legal battle, that it's unfair.
No, well, I think that partly goes to your comment before about whether some parts of the Queensland law might be struck down.
I'd be very surprised if it wasn't subject to a constitutional challenge. I'd be very surprised. As I mentioned before, regardless of what legislation says, there is a thing called the implied freedom of political communication, and laws can't burden that if they don't have a legitimate public purpose and the means used are not disproportionate. There might be a proportionality argument. Can't predict how the High Court will go, but I would be very surprised if there wasn't a challenge to that. And I think it's, obviously these issues are really complex and there's lots of things on both sides, but I think I think we can probably all agree that it's unfortunate that an artist is bearing the brunt of this law when actually the problems lie elsewhere.
And look, I can't comment on the interpretation of the Queensland law. That's beyond my scope and beyond our geography. Certainly, if the piece of art was displayed here, I think we'd end up in, unfortunately, a similar situation. I think Penny and I have, as part of our famous submission, looked at...
Well-leading submission.
We all had a fun.
It's really good.
Which we will also put on the wall here. We have looked at some of those issues about particular phrases, and our view is that the current laws are adequate to deal with those issues in context. We don't need to particularly legislate to try and address some of those concerns because of context. And I think, this particular issue here has highlighted that you can't, it's very difficult to take one line out of context and make assumptions about that. There was a recent case in Victoria which dealt with some chants at a protest, which found that the particular chant did breach the Victorian vilification provisions, but it was also, again, about the context. And so, hence our view is our current laws are adequate to deal with these issues. We don't need to get ourselves into constitutional strife necessarily by going down some of those pathways.
And just briefly, I think on the cross-jurisdictional stuff, it shifts when it's online. I know in the government's consultation discussion paper on the current review, they mentioned some cases where something that was published online in Queensland was seen by someone in the ACT, and that enacted our civil provisions.
So we can certainly deal with anything that a person experiences in the ACT or accesses. It doesn't matter where it's published. That will bring it within, obviously depending on what the content is, but that will bring it within our jurisdiction. Hence, we deal with the TikToks and the online posts and all those sorts of things.
So does that go the other way, that if I publish something in the ACT, it goes to Queensland?
Queensland's got slightly different vilification provisions, so I'm not going to confidently respond to that. You might have.
Oh, I was just going to say, generally as a principle of law, the way it works with cross-border stuff, even between countries, is that if you can access something, then that will be enough. So, for example, there was a big case in France where it's illegal to sell Nazi memorabilia, and an internet site that was hosted in the US was doing it, and that was still caught by French law. So it's not uncommon for when we're talking about criminalising certain behaviours that if the behaviour can be experienced in one jurisdiction, it can still be regulated. And most countries and states are able to legislate extraterritorially for that reason.
So the posters in the window wouldn't be able to be sold in Germany then?
Beg your pardon?
The posters in the window wouldn't be able to be sold in Germany?
That's actually a really interesting question. Possibly not. In France, at least, it may well be a criminal offence, yes. It's possible. Although I don't know if their law has an artistic exception or satire exception, which, they're French, probably.
I'm pretty sure in Germany, it's exempt for artistic purposes.
Yeah.
Otherwise, they would have missed out on a lot of films. For a very long time.
That's true. Well, we might wrap it up there. It's pretty much 7:30 on the dot. I want to say a massive thank you, first of all, to David Howe, for hosting us here at Dissent Cafe and Bar. And going through everything he went through with this incident that kind of brought us here. Please buy all of the drinks to support Dave. He's allowed us to use the venue for free this evening, so if you can support it in any way, there are options behind the bar. And of course, our panelists, Carlo Ritchie at the end. Karen Tui, Discrimination Commissioner in the ACT. Danielle Arlen Piper. And Penny Matthew here.
And thank you, Tom, for having us.
Thank you. Thanks for coming. And thank you to everyone for coming along. Really appreciate it. Have a great night.